Hello everyone, I would like to welcome you to this latest lecture on background of linkage between international law and human rights as a part of the Swayam course on human rights, international humanitarian and refugee law. In this 13th lecture of the series, we will look into the background of the linkage between international law and human rights. To begin with, as discussed in previous lectures, international law and human rights have been frequently discussed together, and it may be considered that they share wide linkages. These linkages are deep and comprehensive, as we learn in today's lectures. In this lecture, we would be covering the following issues which cover these linkages. First, we will be discussing the overlap between international law and human rights, followed by an insight into the idea of how international law has pushed the adoption of human rights among countries. Secondly, we would be discussing the growth of human rights law. This would be followed by a discussion on the wide scope of international law and the principles which have been taken from international law into domestic principles of rule of law. Now, we begin with the origins of the discussion on linkage between human rights and international law. The recognition that rights arising from a treaty which was based on international law could also be given to individuals was laid down in the case of Danzig railway officials of 1928 by the Permanent Court of International Justice. Prior to this, there was an idea that international law treaties could not confer any rights on individuals. As we stand today, international law is potentially the single most important source of human rights law in most countries, wherein the principles of international legal instruments and treaties are used to confer human rights protection on individuals. A few of the earliest international documents which provided rights to individuals are the European Convention of Human Rights of 1950 and the Treaty of Versailles of 1919. Over time, other documents such as the United Nations Charter and a number of international conventions have ensured that human rights are provided to people. An attempt was made to provide rights to individuals without any discrimination right after the First World War, when Japan proposed the Covenant of the League of Nations should state that the equality of nations being basic principle of the League of Nations, the high contracting parties agree to accord as soon as possible to all alien nationals of state members of the League equal and just treatment in every respect, making no distinction either in law or in fact on account of their race or nationality. Unfortunately, this proposal was not accepted by all the countries. The efforts, however, were not fruitless, and the UN Charter imposes a responsibility on all member states to promote universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language or religion. The discussion on human rights in key international treaties has encouraged states to promote human rights in their domestic laws and has elevated human rights as a key domain for protection of rights of the people across the world. The idea of human rights law as has been adopted by states today is a culmination of the idea of forming a set of rules which have been put in place to ensure that basic rights of all the persons living in a particular society are protected. Now, we move on to learn about the growth of human rights law. The growth of human rights law in the international sphere can be seen from the 1900s with the formation of the International Labour Organization in 1919 as a part of the Treaty of Versailles. Following this, nations attempted to look into practices in their own countries which created divisions among different population groups and minorities. The process, however, came to a standstill with the Second World War. After the Second World War, the United Nations Charter and a number of other treaties were adopted by member states of the United Nations. Under Article 68 of the United Nations Charter, a Commission on Human Rights was set up. This commission worked towards the drafting and near global adoption of three key documents in international human rights law. Firstly, the Universal Declaration of Human Rights was adopted in 1948. Second, the International Covenant on Civil and Political Rights or ICCPR was adopted in 1966. And third, the International Covenant on Economic, Social and Cultural Rights was also adopted in 1966. The three instruments and the right proclaimed under those instruments were quickly adopted by countries across the world in their domestic legislation and newly drafted constitutions by independent countries, although it was not without hurdles. In addition to the three instruments mentioned before, a number of prominent international treaties and conventions have been negotiated under aegis of the United Nations, and they include the International Convention on the Elimination of All Forms of Racial Discrimination or CERD in 1965, the Convention on the Elimination of All Forms of Discrimination Against Women or CEDAW adopted in 1979, the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment of 1984, the Convention on the Rights of the Child 1989, the International Convention on the Protection of the Rights of All Migrant Workers and Members of their Families 1990, and the Convention on the Rights of Persons with Disabilities of 2006. These conventions have also found their place in domestic laws after ratification over time. Now students, I hope that you have understood the part, but to test this before we move ahead, let's have a question to revise the part covered till now. So, when was the Universal Declaration of Human Rights adopted? Was it A 1948, B 1958, C 1968 or D in 1978? So, the correct answer for this question is A 1948. Now, let us move ahead. Moving ahead, international law at a regional level has also shaped the growth of human rights. Three prominent regional mechanisms have played a major role in the adoption of principles of human rights. These are the Organization of American States or OAS, the Council of Europe known as COE, and African Union also known as AU. The Council of Europe adopted the European Convention of Human Rights and Fundamental Freedoms in 1950. This is known as the ECHR. The ECHR still forms the backbone in human rights standards in Europe. The Organization of American States adopted the OAS Charter in 1969 and the African Union adopted the African Charter in 1981. All these instruments played a key role in the respective continents in the promotion of human rights principles within the government. The idea was further strengthened since all three institutions have also been successful in forming regional human rights courts for the respective member countries of these organizations. Now, moving ahead, we will discuss the use of customary international law in human rights. So, beyond the use of treaty-based principles and the growth of regional organizations which promoted the protection of human rights, states have also included principles of customary international law into their domestic laws for the protection of human rights. Key principles among them include the prohibition of torture and slavery. The presence of international law and the ratification of the treaties by the states have created an obligation upon them to comply with their obligations under the treaties. This has also encouraged them to comply with more stringent standards for the protection of human rights within their territories. The monitoring of human rights by international bodies such as the European Court of Human Rights has ensured that states are not complacent in complying with their obligations and fulfilling them in accordance with their commitments under international treaties. Even in the absence of any strong obligations, states have also continuously strived to achieve higher standards in human rights protection. Now, students, let's move ahead and see what are the key principles of human rights and international law. So, international law serves as the background for a number of key principles of human rights law which have been adopted by the states. The first among them is the principle of universality. Human rights are applicable to every person irrespective of their gender, nationality, race, religion or any other attribute. The equality of all people to the same rights and freedoms, free from discrimination, is emphasized by this idea. This principle is reflected in the widespread adoption of the principles of human rights protection in constitutions and domestic laws across the world. It is also supported by the idea that major human rights conventions and treaties have been ratified by almost all countries across the world, which has made universality an essential feature of human rights in domestic laws. The second important feature which has been taken from international law is the inalienability of human rights. Human rights are unalienable, meaning no one can ever have them taken away from them or give them up because of their humanity. This idea emphasizes how every individual has inherent worth and dignity, which should always be valued and upheld. In practical terms, this means that human rights cannot be taken away from a foreigner when he is in another country. This principle has been recognized by courts around the world who have ensured that the human rights of foreigners are also protected within their domestic law frameworks. Now, before we move ahead, let's have a question to revise that part that we have covered till now. Are you ready for it? So, here it goes. Which organization adopted the European Convention on Human Rights and Fundamental Freedoms? Is it A, the European Union, B, the African Union, C, the ASEAN, or D, the Council of Europe? I am sure all of you do know the answer, and the correct answer is D, the Council of Europe. Now, moving ahead, the third most important feature is that human rights are interrelated and interdependent, which means that the exercise of one right frequently requires the exercise of another right. For instance, the right against discrimination and the right to equal pay for equal work are commonly interlinked. This idea emphasizes how human rights are holistic and how their protection requires an all-encompassing strategies. In India, the courts frequently have read into the interlinkage of human rights by linking different human rights like the right to a free and fair trial with the right to life and the right to education also with the right to life. Now, the fourth most important feature is the right to equality and non-discrimination. Everyone has the right to exercise their human rights equally and without facing any kind of discrimination. States have a duty to make sure that no person or group is discriminated against on the basis of race, ethnicity, religion, gender, sexual orientation, handicap, or any other basis through laws, policies, or practices. This principle has been included in laws of countries across the world and is frequently reflected in principles like equal pay for equal work. The fifth important feature is the idea of dignity and respect. The tenets of equality, dignity, and respect form the foundation of human rights. Regardless of their circumstances or status, states and other actors must treat every person with decency and respect for their intrinsic value as human beings. It also extends to persons who are in jail or under trial. States are responsible for upholding, defending, and respecting human rights. They also bear the responsibility for any infringement on these rights. Victims of human rights violations have the right to pursue justice for their rights breaches through legal and judicial processes both domestically and internationally. The final element which has been included in domestic law is the idea of rule of law and due process. The principle of the rule of law ensures that laws are supreme and binding on everyone and they are interpreted clearly, openly and fairly in order to protect human rights. People have rights to a fair trial, due process and the assumption of innocence as well as the ability to appeal and be represented by counsel. Some international organizations like the European Union have special mechanisms to ensure that rule of law is protected in the member states, and there are mechanisms to ensure that states which violate this principle are penalized. Moving on to the next topic, we discuss the linkage between international law and human rights through human rights courts. Across different regions of the world, specialized courts known as human rights courts have been created to decide matters involving abuses of human rights. These courts provide a platform for holding people responsible for the violation of human rights accountable, giving victims compensation, and upholding the rule of law. Probably the most famous among these regional human rights courts is the European Court of Human Rights, which is the principal judicial body tasked with interpreting and upholding the European Convention on Human Rights. It is situated in Strasbourg, France. It considers complaints presented against Council of Europe members who are accused of breaking the terms of the convention. The European Courts of Human Rights rulings are legally binding on the governments involved, and the court has made substantial contribution to the growth of human rights law in Europe. The Americas has the IACHR or Inter-American Court of Human Rights. The IACHR is situated in San Jose, Costa Rica and is tasked with interpreting and enforcing the American Convention on Human Rights. It is the judicial branch of the Organization of American States. Cases against OAS member states alleging provisions of the convention being violated are heard by the IACHR. The IACHR has been instrumental in advancing human rights in the Americas, and its decisions are legally binding on the participating governments. In Africa, we have the AFCHPR or African Courts on Human and People's Rights. The African Court on Human and People's Rights is the primary judicial body of the African Union and is tasked with interpreting and enforcing the African Charter on Human and People's Rights. It has its headquarters in Arusha, Tanzania. It is empowered to consider claims against the African Union member states which are presented by governments, non-governmental organizations and people who claim their human rights have been violated in contravention of the Charter. The AFCHPR promotes and defends human beings' rights in Africa, and its rulings are legally binding on the participating governments. Now students, I hope that you have understood the parts till now. Before we move ahead, however, let's have a question to revise the part covered till now. So the question which I hope all of you can answer is, where is the Inter-American Court of Human Rights located? Is it A in New York, B in San Jose, C in Mexico City or D in Toronto? The answer is B in San Jose in Costa Rica. So, moving ahead beyond the regional courts, the International Court of Justice, often called the World Court, has played a key role in development of jurisprudence on human rights. Although resolving disputes between governments is its main duty, it also interprets human rights treaties and conventions and offers advisory views on legal matters that are brought to it by the UN entities. International human rights law was developed in part by the decisions rendered by the ICJ. In all, international law has had a close linkage with the development of human rights law in the domestic law framework of countries across the world. It is expected that these interlinkages will continue in the future owing to continued negotiations between countries on the growth of new principles of human rights, which may then be reflected in conventions and treaties, which can then be ratified and adopted by countries as a part of their domestic law. So, thank you everyone, and we will meet again in the next lecture.